It's still loading on my end.
Jay.
Are you in the VPN, Jen?
Burdens for you.
No.
Okay.
So it's just it's just taking a minute, and
background
as soon as
light.
it loads, we should be ready to go here.
I'm waiting for my flags.
Attendees are in, Jenny, so I think we're
Okay, perfect. And we are live on YouTube, so we are ready to start, Senator.
Welcome. I am Senator Sharon Carson, and I represent Senate District 14. Today, we will be holding a meeting, the first meeting of the Senate Judiciary Committee. Before we get started, I'll read through a checklist to ensure that the meeting we are holding is in compliance with the right to know law. As chair of the Judiciary Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I am confirming that, number one, we are providing public access to the meeting by telephone, with additional access possible by video and other electronic means. We are utilizing Zoom for this electronic meeting. All members of the committee and selective legislative staff have the ability to communicate contemporaneously in this meeting through this platform. And the public has access to contemporaneously watch and or listen to the meeting on Zoom or YouTube, and via phone by following the directions and links provided on the General Court website. Number two, we have provided public notice of the necessary information for accessing the meeting in the Senate calendar. Number three, we are providing a mechanism for the public to alert the public body during the meeting that if there are problems with access, if anyone has a problem, please email remote Senate, that's one word, at leg.state.nh.us or call 603-271-6931. In the event the public is unable to access the meeting will be adjourned and rescheduled. Number five, please note that all votes taken during this meeting shall be done by a roll call vote. And number six, finally, let's start the meeting by taking a roll call attendance. When each member states their presence, please also state where they are and if anyone else is in the room with you during the meeting, which is required under the right to know law. So I will call the roll. Senator Gannon.
Hi, Senator Gannon here in sunny Sandown, New Hampshire. And I do have people in my home Zooming for Timberlane Regional Schools, two of my kids. And my wife is also working out of the house, but they should not be in the room.
Thank you. Senator French. Harold, you're on mute.
I knew I shouldn't have turned it off. French is here in his home in Canterbury, all alone. No one even close, probably, I don't know, quarter mile away, his nearest person.
Thank you, Senator French. Senator Khan.
Present, present in Keene at my home. My wife is probably elsewhere in the house, but not attending.
Thank you, Senator. Senator Whitley.
Senator Whitley is here in my house in Hopkinton, and my family is in the house, but not in the room.
Thank you. And Senator Carson, I am at my home in Londonderry, and I have a cat running around here someplace, but other than that, I am alone. And we also have members of our staff, if they would like to just introduce themselves and let us know where they are. Ms. Horgan.
I'm Jenny Horgan. I am in Manchester, New Hampshire.
Ms. Waterhouse.
Hi, I'm Margaret. I'm here and I am alone in my house.
Thank you. And Ms. Mello.
Hi, I'm Trisha Malillo. I am in Amherst, New Hampshire, and my husband is in the house, not in the room.
Thank you all very much. We're going to go ahead and start the day by opening the public hearing on Senate Bill 16. I'm going to have to step away from the chair, and I'm going to hand the gavel over to Senator Gannon, who is going to go ahead and open this up because the first bill is mine. Thank you, Senator Gannon.
Thank you. Okay, opening up Senate Bill 16, and we recognize the Honorable Senator Sharon Carson.
Thank you very much, Senator. I have for your consideration this afternoon, Senate Bill 16, which calls for amending the alimony statute due to changes in federal law. This bill recognizes the formula for term alimony because of recent changes in federal income tax law. The bill recognizes that alimony is no longer either deductible by the payor or taxable to the payee. This bill is a bill that was filed last year. And unfortunately, it got rolled into one of the large omnibus bills and was vetoed. So I'm reintroducing this. This is a bill that we really need to pass because of changes within the tax law. And so we have to be compliant with federal tax law. So at that point, you should have all received copies of all the information from the public hearing that took place last year. And I'm going to go ahead and conclude my testimony, and thank you all very much for your attention.
Do any senators have any questions for Senator Carson? Yes, Senator Whitley.
Thank you for taking my question, and thank you for introducing this bill. Just a quick question on, I noticed there were some amendments that were introduced in the Senate the first time around, and I just wanted to confirm that those amendments were included into this version of the bill.
Thank you very much, Senator. Yes, they were.
Thank you.
Any other questions for the senator?
Mr. Chair.
Oh, I'm sorry, Senator Khan. I didn't look low enough. Go ahead, sir.
Thank you, Chairman. Senator Carson, I was in the intervening period. Can you or anybody else who might be testifying today discuss what's happened in that intervening period? Have court orders continued the 30% rule?
Thank you very much, Senator. There are a number of people that are going to be speaking who will be able to answer that question specifically.
Thank you. Anyone else? Thank you, Senator Carson.
Thank you very much, Senator. I'm going to
Hand
go
the
ahead
gavel
and
back to you.
take the gavel back. And the first person that we have is Honey Hastings.
Okay. You may
I'm
speak.
here. I'm here. Can you hear me?
Yes. Go ahead.
My name is Honey Hastings. I'm a retired family law attorney, about 34 years of experience, but I've continued work as a mediator both in the court system and privately. The effort to modernize the alimony law began in 2015. It took some time. The problems with the old alimony law, it was unpredictable. It was so vague, so much discretion that it made it hard to settle cases. And I saw this both in my years as an attorney and certainly in my work as a mediator. Lawyers couldn't predict how things would turn out in litigation because it was, and in fact, it might depend upon what court you were in or who was the judge. So a group of lawyers got together with some divorce financial analysts and developed what became Senate Bill 71, which passed in 2018 to achieve predictability and consistency in the alimony law. It came up with a workable formula that seemed to result for the amount of alimony that seemed to result in fair amounts of alimony in appropriate cases. One of the factors, important factors of the formula was at the time, at the beginning of 2019, when it took effect, alimony was a deduction for the person paying it, and it was taxable income for the recipient. As you know, that federal tax law, one of the kind of principles it did was eliminate many deductions. At the same time, it increased the standard deduction. That was part of the policy of that bill. And one of the deductions that went away was the deductibility of alimony. But at the time we wrote the bill and did the analysis and the financial analysts crunched the numbers for us, 30% seemed to come out to a fair after-tax result for both the payor and the payee. But when this law changed, and it was primarily the deductibility, but it was also the change in tax brackets and in the tax itself, the old arithmetic we had done no longer worked. So the group that I had worked with got back together and tried again to see what would come up with what percentage would come up with a fair result. After doing a lot of calculations, again, relying on these professionals called divorce financial analysts, we came up with 23 as the right percentage. It produces similar after-tax numbers for both payors and payees that were achieved before the tax law changed. This is really a housekeeping correction to deal with the federal tax law changes. Also, we've added a new section to the old law, the law that took effect in 19, to make it clear that one of the special circumstances that would justify varying from the formula would be if there's an impact of federal tax law, just knowing that they might do something else. We also put in, if they went back to having it being deductible, we'd go back to 30%. The bill is a bill that should take effect immediately, and it says that. It also indicates that if alimony was decided from January 1st, 2019, and use the 30%, which would result in a higher amount, this could be changed to, or used any number more than 23%. People could get back in for a modification with an easy standard, not the tough standard that's built in general for modifications. The bill also clarifies that the 2019 alimony statute applies only to divorces filed in 2019 and later, not to old ones or modifications thereof. This was in the original bill. Unfortunately, for the public, and even, I must say, for some lawyers, it was in the session law part of the bill, and people had trouble finding it. So this bill, as part of the correction and clarification, puts it over in the RSAs. So everyone can find the provision that says, if you have an old alimony order, you can't come back and get the new law. It only applies to new cases. And I would be happy to answer any questions.
Well, you may want to unmute.
Senator Carson, you're muted.
That's okay.
Thank you very much for your testimony this afternoon, Ms. Hastings. Are there any questions from the committee? Senator Khan?
Thank you, Madam Chair. And Ms. Hastings, I think you've put the bill together in a manner that makes sense for the date of effectiveness. But there have been some renderings since then, right over the last year plus 2 years, I guess, that have settlements that are 30% without taxation. Is that correct?
Yes. Yes. This was also raised, I believe, by Senator Whitley, that the question of what has happened in the interim. First of all, I would call your attention to page 2 of the bill, line 8. Any alimony order effective on or after January 1st, 2019, including one based on an agreement of the parties, may be modified without the need to demonstrate the tough standard, provided that it was issued pursuant to the law that was that came in then, and the alimony amount is greater than 23%, because some people might have reached a compromise. Someone said, oh, it's still 30% in the law. Oh, well, but we understand it may get changed to 23. Okay, let's use 27. So anything that came in that time period, provided they file a petition for modification within a year by July 1st, 2022. And so what has happened is people have settled these cases. I hear more about that than to know what judges have done. And people who have settled, some of them, including some cases I've mediated, have just said, well, we understand 23 is the right number. So since we're reaching agreement, we're just going to use 23%, even though the law says 30. Some have agreed to a intermediate percentage. Some have agreed, okay, it'll be 30, but when the law gets amended, it'll change to 23%. So there have been a number of adjustments that people have made, reaching agreement. I think judges may be using 30, but given the number of judges in the family court, I'm sure there are judges who are using 23 or using some other number. They do have discretion to vary from the formula in any event, and they might find reasons in addition to the federal tax law change to make that adjustment.
Thank you. I think I understand then that there are some people who, when this, if it's passed, will feel the financial impact negatively as a result. I just wanted to get a sense that there will be some instances of that.
Well, yes, and again, we regret what happened last spring to the bill. It passed this committee unanimously. It passed the Senate unanimously. It got to the House and was scheduled for a hearing. And days before, less than a week before the hearing scheduled in the House committee, COVID struck. And then, as Senator Carson mentioned, it was put in an omnibus bill which had many other worthy non-political things. And this is non-political, non-partisan, but it got caught up in the COVID and politics thing last year.
Thank you.
Are there any further questions from the committee? Okay, seeing none. Thank you very much, Ms. Hastings. Next, we're going to hear from Carolyn Lear.
Okay.
Good afternoon, Ms. Lear.
You can unmute, Ms. Lear. Maybe she's not there. Ms. Lear, are you on?
Okay, why don't we go ahead and we'll call someone else. I'm going to call Marissa Chase.
Ms. Chase, you can speak now.
Hi, everyone. Good afternoon. Thank you, Senator Carson, for introducing this bill. And thank you, members of the committee, for hearing it and asking really good questions. I just wanted to offer the New Hampshire Association for Justice's support of Senate Bill 16. This is an issue where I've received many calls from family law attorneys over the past year while this bill was pending last session, wondering the status of it, as it does impact cases, and cases are people. So this does have a great impact on individuals, and our members are looking forward to having some further guidance on this alimony statute. So thank you again, Senator Carson, and I will let those more knowledgeable about the intricacies of the law speak and not me.
Thank you very much, Ms. Chase. Are there any questions from the committee? Okay. Seeing none, thank you all very much. Next, we're going to hear from Mary Kruger.
Can you hear me?
Yes, we can.
Yes.
Okay. Thank you, members of the committee. My name is Mary Kruger. I'm an attorney at New Hampshire Legal Assistance. We're a nonprofit law firm. One of the things that we do is family law for domestic violence, sexual assault, and stalking survivors. We were a part of the alimony working group that Honey Hastings chaired, and helped also think about how to make this change after the federal tax laws changed, as Honey explained. And looking at this through the lens of how it would impact, in particular, low-income survivors of abuse. We saw that this is, the 23% is a fair way to adjust the formula accordingly to account for the federal tax law changes. So we are in support of this change. Thank you.
Thank you very much for your testimony, Ms. Kruger. Are there any questions from the committee? Okay, seeing, oh, Senator Khan.
I'm just curious, your legal assistance, it's a lower income clientele, I assume that you're primarily serving. Is 23% help? I mean, it helps, certainly. Is it sufficient for sustaining people who have gone through this kind of domestic violence and the divorce that results from that? Is the 23% a fair number today as you reflect on it?
I believe it is. It's 23% of the difference in the income. In the kinds of cases that we see where there's been financial abuse that goes along with the other kinds of abuse, the person that we're advocating for tends to have little to no income or disability income only, which is lower income. And so we, in looking at all the models, really advocated to ensure that there would be sustainable income for the spouse who is the abuse survivor, who may not have a lot of prospects for future, especially in later in life situations where there's been a long-term marriage. So we did spend a great deal of time looking at these numbers, and the 30%, accounted for it being taxable income for the recipient, in addition to it being a tax deduction for the payor. So the 23%, when we looked at that, we looked at, I think, 27%. We looked at a bunch of different models. It seemed to really track what the 30% had accounted for. And we also looked at other states to see how their alimony formulas also compared to what New Hampshire was contemplating doing. And I think it has been a fair way to help us resolve some of these cases in ensuring that there is sustainable income for the abuse survivor. I would also say that we can't emphasize enough how the formula has allowed for much more predictability and consistency in our courts, where it was really all over the map, and we were seeing abuse survivors really not having orders that would be in terms of duration long enough that we felt some of the courts really just misunderstood the need, misunderstood the ability for abuse survivors who may have many effects of trauma, the impact on their ability to become, quote, rehabilitated for work. And so the gains of having a formula like this have been amazing. And so the 23 compared to the 30, I think, is fair in the models that we looked at. And I can't emphasize enough how Honey's pulling in some of those financial experts really helped us to, drill down on some of these numbers so that we do have what we believe is a good number with the 23.
Thank you.
Senator Whitley.
Thanks for that information, Attorney Kruger. As a follow-up to that, I'm really interested in knowing, in arriving at that number, the 23%, which is really specific, and I know that it included a lot of financial analysis and comparison with other states. I'm curious where that number is with some other states you looked at it. Is it above, below? Where does that 23% fit in with other states? Thank you. Thank you for
Sure. So I may defer to see if Honey has some of those models in front of her. I do not, and I apologize to the committee. I believe that Massachusetts is, and I understand sometimes Massachusetts is not always favored in this state as the place to look, but I do think they have a similar number as to what we're looking at. There's a handful of states that use a formula, so it's not like a huge number. There's not like an overwhelming majority of states that we can compare our formula to. It's a relatively innovative approach with this law that did pass. And so, we're somewhat, I think, in the forefront of that with a handful of other states that have decided to make these changes. So perhaps Honey could be more specific as to the numbers, or we could follow up to the committee with more information on that.
Thank you. Are there any additional questions? Okay, seeing none. Thank you very much for your testimony, Ms. Kruger.
Thank you.
I'm going to go ahead and try Ms. Lear again. Can we see if she's back?
Yes, we can. Ms. Lear, you are able to talk?
I was expecting just to listen in. Did the committee have specific questions for me?
It appears that Ms. Lear is here representing the DRA, our Department of Revenue. And are there any questions from the committee for her about taxes, tax implications, any of those things? Okay, I don't see any. Thank you very much, Ms. Lear. We appreciate you taking the time to see if we have some questions. Okay. Do you know if Ms. Hastings is still on the line, or
Yes,
is she?
She is. We also have one more speaker, Kathy McKay.
Okay, she's new. Okay. Oh, no, she isn't. Okay. No, why don't we go to Ms. McKay and then we'll go to Ms. Hastings.
Okay. Ms. McKay, you should be able to speak now.
Thank you. Can you hear me?
Yes, we can.
Yes, we can.
Okay, perfect. Thank you. This is Kathy McKay. I'm an attorney in Londonderry, New Hampshire, and I practice in the firm of Parnell, Michaels, and McKay. I handle a large majority of the family law cases in our office, and I've been doing this for about 28 years now. Thank you, Madam Chair, for bringing this legislation forward again this session. My colleagues and I are very grateful to you for doing that, as it's an important issue that really needs to be done and should have been done last year. I do echo everything that Honey Hastings and Mary Kruger have had to say with the importance of this bill, and urge the committee to vote Senate Bill 16 to pass. We have seen a number of cases already from judges applying that 30%, and it, with the tax change, it's really devastating to the paying party who's losing out on a large portion of income that they would have gotten back otherwise through the tax deductions, but are now just paying that money out. And so I do support the passage of this bill, and I'm happy to answer any questions that you may have. Thank you.
Thank you very much, Ms. McKay. Are there any questions from the committee? Okay, seeing none. Again, thank you very much for your testimony this afternoon. Why don't we see if Ms. Hastings is here and would like to get a follow-up question?
Yes, Ms. Hastings, you should be able to go now.
Okay, Senator Whitley, I believe, has a question for you.
Thank you, Madam Chair, and thank you, Attorney Hastings, for coming back. The question was just on this number that the group arrived at, the 23% number, and how that does compare to other states. We heard that only a handful of states use the formula, so New Hampshire is fairly innovative, but I would be interested in hearing the formula number that other states have arrived at. Thanks for taking my question.
Senator, I'm afraid I don't have a great answer, but I think I have some information that might help clarify it. When we did the original calculation, again, we were working with these divorce financial analysts who can take, if there's 0 children, 1 child, 2 children, 3, we calculate the child support, because child support is calculated first under the alimony law, and then they can tell the tax implications of getting the exemption for the children, how those are divided up, the tax bracket the person is in, and then we put the alimony on top. And what they came up with when we came to the 30 originally was, what is each household going to have in terms of after-tax income, considering child support, paying it, receiving it, alimony, paying it, receiving it, tax benefits, good and bad for each side. What are they each going to have? And we looked at the only state that I remember, and I'm sure we had some other numbers, but this was like in 2016, and I'm 77, so I don't remember. They had 30 to 35% was the Massachusetts original number, which was adopted in 2013. We decided that a range of numbers was not very helpful. We wanted predictability, so we, after we looked at the numbers, we thought they were in the right ballpark. But when we did the numbers, we said, 30%, understand that the law has in it a section allowing the judge to use discretion to vary the formula for various reasons. And there's a whole list of reasons to which has been added, will be added under this bill, any further tax implications. So, disability, supporting adult disabled children, just the period of the economic disadvantage of the person receiving it. So they can choose, they can calculate the number and then say, yeah, but we think that this comes out with $1,000, and we think that really the right number, given the discretionary factors, is $1,200, and they can order it. And when people reach agreements, they also look at these discretionary factors and interrelate with it the property division, because there are, in cases where there might be alimony, 2 key things. There's the alimony and there's the property division. If there's kids, there's a third one. And some people say, well, I can take less alimony as long as I don't, you give me the house and I don't have to pay anything. Or someone say, I can afford to pay a little more alimony if I don't have to give you any money to buy out of my business. So that there's an interaction of those 2 things. When it came after the federal law changed and we had to look at this again, we did not at that point do any study of other states. We said we liked what we did and we liked the result, the after-tax result for different family situations by income, by number of kids. So what we did is we just did more calculations with the new tax law, federal tax law in place. And in fact, we did more because, and I think this was suggested by Attorney McKay's comments, that we heard particularly there were problems at the higher income levels. So we added some more scenarios that had higher income. So we looked at both cases of the sort that Attorney Kruger handled with the New Hampshire legal assistance, and lots of middle income and then some very high income scenarios, and concluded that to get results similar to the ones we felt confident in before, the 30% produced with deductibility, that 23 was the right number. And we did look, as Attorney Kruger mentioned, at 27%. I think we even looked at 20. We looked at a number. It just came out of it that 23 worked for most people, given that there are discretionary factors which can make it change, and not mentioned because it's not related to this bill, but the other part of the formula is there's a formula for duration, which is half the length of the marriage.
Thank you very much. I appreciate that.
Oh, yeah. Are there any further questions for Ms. Hastings? Okay, seeing none. Thank you very much, Ms. Hastings. Are there any other members of the public who would like to speak to this bill?
And if there are, you can either raise your hand on your Zoom screen, or you can, if you are on the phone, dial *9, and that will virtually raise your hand. I don't see anyone, Senator Carson.
Okay, well, all right then, I'm going to go ahead and close the public hearing on Senate Bill 16. Okay, what do you folks think? Are you ready to exec this bill? Okay, can I get a motion to go into executive session?
Motion to go into executive session.
Okay, moved by Senator Gannon, seconded by Senator Khan. I saw Senator Khan's hand up. Okay, I'm going to go ahead and call the roll. Senator Gannon,
Yes.
Senator Whitley,
Yes.
Senator Khan,
Yes.
Senator French,
Yes.
and Senator Carson. Yes. Is there a motion on this bill?
I move on to pass.
Okay, Senator French moves ought to pass. Is there a second?
Second.
Seconded by Senator Whitley. Okay, is there any discussion on the bill? Seeing none, I'll go ahead and call the roll. Senator Gannon,
Yes.
Senator Khan,
Yes.
Senator Whitley,
Yes.
Senator French,
Yes.
Senator Carson, yes. Okay, Senator French, would you mind if I took this one out and wrote the blurb?
Senator, do you want to put that one on consent or?
Oh, that's right, I forgot about the consent calendar. Is there a motion to put this on consent calendar?
So moved.
Okay, I see who said so moved. Second, Senator Whitley moved to put it on consent. I saw Senator Khan raise his hand again, so Senator Khan has seconded. So this is to put the bill on the consent calendar. Senator Gannon,
Yes.
Senator Khan,
Yes.
Senator Whitley,
Yes.
Senator French,
Yes.
and Senator Carson, yes. So the bill is voted ought to pass, and it is on the consent calendar. And Jenny, I will work and we'll write the little thing we need to do. Okay. The next bill was scheduled for 1:30, and seeing that it's after 1:30, we're just going to go right into opening the public hearing on Senate Bill 28 and recognize the prime sponsor, Senator Gaida.
Senator Gaida, you may. Yep, there you go.
Thank you, Madam Chair, members of the committee. It's my pleasure to be here today. This is a relatively simple bill honoring a very distinguished member of our judiciary who is retiring. And I'll read a letter that I forwarded to the members of the committee for the record. Dear Senator Carson and members of the committee, I'm here today to introduce Senate Bill 28. This bill names a courtroom in the Second Circuit Courthouse in Plymouth in honor of Judge Edwin W. Kelly. I was contacted by Senior Judge Tom Rappa, who wanted to recognize Judge Kelly for his more than 30 years of service that he's given to our state. Judge Kelly recently retired, but served both the state of New Hampshire and our judicial system with distinction. He has garnered wide praise throughout the Plymouth and legal communities for his demeanor, his fairness, and his knowledge of the law. Some of his accomplishments include helping to create the family division within the court system, working on bail reform, Most notably, Judge Kelly helped create the Circuit Court in 2011, which then Chief Justice Robert Lynn noted was, quote, a Herculean task, end quote. Throughout his various roles in the judicial system, Judge Kelly's left an indelible mark and earned the respect of staff, judges, citizens, and other stakeholders at the court. He helped define the role of an administrative judge in responding to citizens and other stakeholders who had less than positive experiences with the judicial system. I believe Judge Kelly exhibits all the attributes that one would look for in a great judge. I hope the committee will look favorably upon this bill and vote the bill ought to pass. Thank you, Madam Chair and members of the committee.
Thank you very much, Senator Gaida. Are there any questions of the committee for Senator Gaida? Senator Whitley.
Thank you, Madam Chair. Senator Gaida, I just wanted to make sure, I didn't get your letter, so I don't really have a question. I just wanted to make sure that you had sent it to the right place. So it's not really a question. I just wanted to make sure that that went to the committee.
I will defer that to my staff, Griffin, and I'll be certain that all the members of the committee do in fact get a copy if it has not been done already.
Thank you, Senator.
Sure.
Are there any further questions? Senator Khan?
Thank you, Madam Chair. Thank you, Senator. I've noticed that from the naming bill last session, this naming bill, we've got some trend going, which is good to recognize those who've served in our judicial branch for a long period of time. I'm curious, though, just how long did Judge Kelly serve in the circuit court? You know?
I don't know the answer to that.
And not that time should be a litmus test, Senator, don't misunderstand. I just, I recall from that he's quite distinguished in some of the areas that child law is what I recall. But anyway, maybe that's addressed in your letter. Thank you.
Are there any further questions from the committee? Okay, seeing none. Thank you very much, Senator Gaida.
Thank you, Madam Chair, members
And
of
we
the
look
committee.
forward to getting that letter.
Yes, ma'am. Thank you.
The next speaker is Representative Ned Gordon.
Okay. Representative Gordon, you may begin your testimony. Representative Gordon? You are on mute, Representative. Okay, there you go.
Yep. Good afternoon, everyone. Madam Chair, members of the committee, my name is Ned Gordon. I represent Grafton County District 9. I've known Ed Kelly for 35 plus years. I know when I first knew him, he was a judge. So he has a long tenure. I don't know exactly how long that is. As a new lawyer, I tried my first case in front of him at the old courthouse in Plymouth. And I worked with him and former Representative Driscoll from Plymouth in putting together the package and the creation of the new courthouse, which we do have in Plymouth. Three reasons why I think Ed Kelly should be recognized. One is he's created a professional judiciary. When he first became a judge, the district court judges, virtually all of them were just part-time judges. And now virtually all of the circuit court judges are full-time judges. We have a professional judiciary. The second thing he did was he consolidated the courts, as Senator Gaida already mentioned. He was largely responsible for the creation of the circuit court and the combination of the courts, which has created not only efficiency, but huge cost savings to the state. And finally, he's brought technology to the courts. And you probably are aware of the fact that the circuit court under his direction was the first court to have electronic case filing. He's had a huge impact on the courts and the people within the courts and the court system as a whole. And I certainly would, I think, is naming a courtroom after him is just a modest recognition of all he's accomplished. Thank you very much.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Okay, seeing none, thank you very much for your testimony.
Thank you, Madam Chair.
Next, we'll call Thomas Rappa.
Mr. Rappa, you can unmute. There you go.
Madam Chairman and members of the committee, good afternoon. I am Thomas A. Rappa Jr. I live in Bath, New Hampshire. I've had the distinct honor of serving as a judge in what is now the Circuit Court for over 32 years. Most of that time, I actually sat at the Plymouth Circuit Courthouse, which is the subject of the bill currently considered by the committee. I'm here today to speak in support of Senate Bill 28 and encourage you to move to pass that legislation to commemorate the remarkable career of my colleague, the Honorable Edwin W. Kelly. To answer Judge Kahn's earlier question, Judge Kelly was appointed to the what was then the Municipal and District Court in 1985, and he has served with distinction. He quickly endeared himself to the Plymouth community as a judge, first as a lawyer, and then as a judge based on his judicial demeanor, his fairness, and his knowledge of the law. In 1991, the Supreme Court tapped Judge Kelly to serve as the first administrative judge of what was then still the District and Municipal Court. Over the next 2.5 decades, Judge Kelly defined that position as he guided the court into the modern era. In my humble opinion, as New Hampshire's first administrative judge, Edwin W. Kelly did more to provide fair and efficient access to judgment to the citizens of New Hampshire than any other individual who's ever served in the judicial system. To understand the magnitude of Judge Kelly's contributions to the administration of justice, you need to first understand that prior to his role as administrative judge, the individual courts were essentially private fiefdoms with no standardization of process, no standard procedures, and each judge was acting virtually unto himself as to how the court was run. Judge Kelly initiated regular judicial education and a systematic judicial evaluation process for sitting judges. He created consistency throughout the court system by issuing clear and thoughtful administrative orders related to judicial process and procedures. He was instrumental in creating protocols for processing domestic violence cases and for processing child abuse and neglect cases. He advocated for community outreach to improve the judicial system by seeking the input from the numerous stakeholders that were served by the system and involving them in the process to create a system that worked for everyone coming to the court. As has been mentioned, he oversaw the creation of the family division, fostering the concept of one family, one judge. He was a zealous advocate for justice, appearing before numerous committees in your legislature to speak on laws impacting the judicial system. He became an eloquent advocate for justice at untold community meetings, panel discussions, other community events, and encounters with the press, and always displayed professionalism tempered by empathy and compassion. He oversaw the implementation of technology that took us from a situation when we first started, we were using Wang computers that had a unique DOS operating system. There was no interconnectivity, no internet, no email, no easy access to statewide court records, and brought us into the modern era with a modern intranet through the whole court system that allows judges to interact with each other on a regular basis, creating a more consistent administration of justice and creating better access to records, improving the process for everyone. He spearheaded, as has been mentioned, the ongoing movement toward paper-on-demand courts by overseeing the implementation of the electronic filing system. And believe me, that was no small task. One of his roles was to oversee the construction of numerous modern courthouses that also improved access to justice and made the courthouses safer for the members of the community that were there to deal with their respective issues. That includes, by the way, the Plymouth Circuit Courthouse, which is subject to this bill. And perhaps one of his most crowning achievements was the creation of the Circuit Court in 2011. And he was certainly proud of his effort to implement bail reform as one of his most recent accomplishments. Over the 29 years he held the office, Judge Kelly defined the role of the administrative judge, and in doing so left a positive legacy that will benefit the judicial system and the citizens of New Hampshire for decades to come. These achievements did not come without great personal sacrifice. Having worked in the same building with Judge Kelly for decades, I was painfully aware of the many late nights and early mornings he contributed to the judicial system. His dedication and selflessness were unparalleled. Upon stepping down as administrative judge, the then New Hampshire Supreme Court Chief Justice Robert Lynn, who I believe is a co-sponsor of this bill, declared, quote, "Judge Kelly embodies all the qualities that you look for in a great judge. He's fair, he knows the law, he has always shown excellent judicial temperament, and he has been a first-rate administrator. I cannot say enough about Ed's outstanding service to the judicial branch, both on the bench and as an administrator," end quote. I personally could not have said that better. I'm immensely proud to call Ed Kelly a colleague, a mentor, and a friend. However, we, the citizens of New Hampshire, owe Judge Kelly our highest respect and sincere gratitude for his outstanding service and significant contributions to the judicial system. I ask that you move to pass this bill to create a lasting symbol of our appreciation for his efforts. Candidly, when I approached Senator Gaida, I requested that they name the entire courthouse after him. But apparently there's a policy that it's only a courtroom. I respectfully submit that that isn't enough to show our appreciation for this great man. And in closing, I reiterate, no one has done more to provide fair and efficient access to justice to the citizens of New Hampshire than Ed Kelly. I urge you to pass or move to pass this bill, and thank you for your time.
Thank you very much for your testimony, Mr. Rappa. Are there any questions from the committee? Okay, seeing none, thank you very much again for your testimony this afternoon.
Thank you.
Are there any other members of the public who would like to testify on this bill?
If there are, you can just virtually raise your hand. I do not see any. Senator Carson?
Okay, thank you, Ms. Melillo. I'm going to go ahead and close the public hearing on Senate Bill 28. What do you folks think? Would you like to go into executive session and vote on this bill? Okay, so can I get a motion to go into executive session?
So moved.
Okay, Senator Khan is moved. Is there a second?
Second.
Seconded by Senator Whitley. Okay, we need to call the roll. Senator Gannon,
Yes.
Senator Khan,
Yes.
Senator Whitley,
Yes.
Senator French,
Yes.
and Senator Carson, yes. Okay, is there a motion on Senate Bill 28?
Motion to move to consent,
Okay,
or we have to,
yes, we're a motion. Are you moving ought to pass, Senator Gannon?
yes.
Okay, Senator Gannon moves ought to pass. Is there a second? Senator Khan seconds the motion. Is there any discussion on the bill? Senator Khan?
Madam Chair, and I was trying to recall the history that we've heard from the two distinguished judges that provided testimony today, Judge Gordon, Representative Gordon, Chairman Gordon, and Judge Rappa. I mean, the passion that Judge Rappa put to the career of Ed Kelly, and the history that precedes even Ned Gordon as a judge, I think make me recall my time with the CASA board, court appointed special advocates, some 15 years ago. But I recall Marty Sink, still director of CASA, who brought Judge Kelly several times to the fore because of his advocacy for family courts and justice for kids from abused and neglected homes. He was a passionate advocate, and just the testimony that folks have provided today, I think, reinforce the importance of the bill that's before us. I guess I'd just add, while I have the floor, that perhaps consent is not what I recommend, because I think that our colleagues should have that opportunity to recall the service of Judge Kelly. Thank you, Madam Chair.
Thank you very much, Senator Khan. Is there any further discussion? Okay, seeing none, I will go ahead and call the roll. Senator Gannon?
Yes.
Senator Khan?
Yes.
Senator Whitley?
Yes.
Senator French?
Yes.
Senator Carson? Yes. And I would agree with our colleague, Senator Khan, that I believe that this deserves a good discussion on the floor, where people will be able to talk about Judge Kelly. So Senator Khan, would you like to take this bill out? Yes?
Yes.
Okay. Okay. Can I get a motion to come out of executive session?
So moved.
Okay, Senator Whitley, is there a second?
I want to stay in.
I know you do, Senator French. Senator Gannon, a second. I'm going to go ahead and call the roll. Senator Gannon?
Yes.
Senator Khan?
Yes.
Senator Whitley?
Yes.
Senator French?
Yes.
And Senator Carson? Yes. So seeing that we have concluded all of our business today, we are done. Do I need to take a roll call? I see Tricia going yes. So we are concluded our business. And so I will just take a final roll call. Senator Gannon?
Here, present.
Senator Khan?
Yes. No, I don't know if we needed to make a motion, but.
Well, we're just, I guess it's just, we're concluding business for today.
Yes.
Senator Whitley?
Yes.
Senator French?
What exactly are we doing? Roll call or motion?
Yeah, we're just concluding business for the today, and we're just saying, taking a roll call that we're concluding business.
Yep. Motion to adjourn. Yep.
Motion to adjourn. There you go.
Senator French, yes, and see you all later.
All right. Take care, Senator French. And Senator Carson, yes. Thank you all very much. Many thanks to our
Senator, I'm
staff.
sorry, Senator Khan has his hand up.
Oh, Senator Khan?
Are we having a meeting next week?
I don't know yet. I haven't received any bills. So when I receive the bills, Jenny will let me know and we'll go ahead and schedule. Okay?
Yes.
Okay. Is there anything else anybody would like to talk about, or?
Thank you for running a smooth meeting, Madam Chair.
Kind of smooth, not as smooth as it, but there's different parts than when you're actually in person having a meeting. So, but I think everything went well. And,
Great job.
Oh, thank you, Senator French. So we have concluded our business for today. Many thanks to our staff. for helping this go so well. And I look forward to working with all of you as we continue on through the biennium.